Hello, my name is Matt Williams. I'm a criminal defense attorney in Cleveland, Ohio. I'm making this video to answer two important questions that people often have as they work their way through the criminal justice system. The first question is, if I've been convicted of a criminal offense as an adult, can I have my record sealed? And the second question is, if I'm considering pleading guilty to an offense as an adult, will I later be able to have that record sealed? So this video is to explain the eligibility rules for the process commonly known as expungement, which is actually having the record sealed. Expungement technically means the record is destroyed, and that only happens in juvenile cases in Ohio. But expungement is the term that people use on the street. It's the term that you're going to hear generally if you're talking to lawyers. It's also the term you're going to hear me use today simply because it's how people talk. Basically, I want to explain the eligibility rules for adults who have been convicted of a criminal offense or offenses. So this does not apply if you were acquitted. It does not apply if your case was dismissed or no billed, and it does not apply to juvenile records. This video is solely to explain the eligibility rules for adults who have been convicted of an offense or offenses under the criminal code here in Ohio. Now, if you have been convicted of an offense as an adult, it's possible that your record of that offense can be sealed, but there are a lot of rules regarding which records can be sealed and when and how that occurs. So first I want to go over the exceptions. These are crimes for which the record cannot be sealed. It doesn't matter how many times you ask the judge. It doesn't matter how good your reasons are. The law simply does not allow the court to seal the record for these offenses. Those are felonies of the first and second degree, crimes for which a mandatory prison term was imposed. It's important in the mandatory prison term category not to get confused between mandatory prison and mandatory post-release control. Mandatory post-release control is a common feature of many sentences in the state of Ohio. It is not mandatory prison, but it will say somewhere in the judgment entry mandatory post-release control, or you may hear that in court. Just because there's mandatory post-release control does not mean there's mandatory prison. What you're worried about is actual mandatory prison time. If that's imposed, the record cannot be sealed. Next, we have your serious sex offenses. The records for these can't be sealed. They are rape, sexual battery, unlawful sexual conduct with a minor, gross sexual imposition, pandering obscenity involving a minor, pandering sexually oriented material involving a minor, illegal use of a minor in a nudity-oriented performance, and importuning on or after October 10th, 2007. We also have lesser sex offenses, which you cannot get the record sealed if the conviction occurred on or after October 10th, 2007, and the victim was a minor. Those are voyeurism, public indecency, compelling or promoting prostitution, soliciting or procuring prostitution, disseminating or displaying matter harmful to juveniles, pandering obscenity, or deception to obtain matter harmful to juveniles. Again, for that list, the record cannot be sealed if the conviction occurred on or after October 10th, 2007, and the victim was a minor. Next category is driving offenses. I know it's a little less serious, but your driving and motor vehicle offenses in the state of Ohio records cannot be sealed. Those are any offenses under Chapter 4507, 4510, 4511, 4549. Probably the most common example of this is DUI or reckless operation charge. People would like to have off their record do a job that requires some driving. Unfortunately, the records for those cannot be sealed by law. Next, we have offenses of violence. Offenses of violence, there's a long list of them that I'm not going to read to you. It's mostly common sense, with the exception of burglary. People often get confused and don't think burglary is an offense of violence. Burglary is considered an offense of violence in the state of Ohio. You cannot get the record of an offense of violence sealed if the offense was a felony or a misdemeanor of the first degree, except misdemeanor 1 assault, riot, inducing to violence, and inducing panic. Those four are accepted. You can get those records sealed. We also have felonies or misdemeanors of the first degree where the victim was under the age of 18, with the exception of non-support under Chapter 2919.21. You cannot get a felony or first-degree misdemeanor record sealed if the victim was under the age of 18. So that is the exceptions. Those are the things that you cannot get sealed. If your crime or record is anything other than that, the next thing we have to talk about is how many convictions you have. It used to be the case in the state of Ohio that you could only get your record sealed if you had one criminal offense. They loosened that up a little while ago, and they've actually loosened it up a little more this fall. Right now, you can get your record sealed if you have one felony and one misdemeanor, or two misdemeanors. Now, the two misdemeanors, until just recently, it had to be two different misdemeanors, things that were not the same offense. As of September 19th of 2014, you can now get two misdemeanor convictions sealed, even if those records are for the same offense. We're all very thankful for that, because usually when you're looking at two misdemeanor convictions, they were for the same offense. So provided your offense is not an offense that was accepted, the serious ones we talked about before, the driving offenses, as long as you have only one felony and one misdemeanor, or two misdemeanors, you are eligible to have those records sealed. Counting does get a little more complicated because there are some rules that let you count multiple convictions as one for the purpose of expungement. Those are that if you have two or more convictions resulting from the same act or offenses committed at the same time, those count as one. If you have two or three from the same indictment, information, complaint, plea, or proceeding that were related criminal acts which occurred within a 3-month period, the court may count those as one. The court can decide in that case that it's not in the public interest to count those as one and count them as multiple convictions. But if you have two or three that were taken care of in the same case, the same indictment, information, or complaint, the same plea of guilty, or the same proceeding, and they are related criminal acts within a 3-month period. Now, typically where you find those is with people who have a substance abuse problem and they committed 2 or 3 drug offenses or 2 or 3 theft offenses in a short period of time when they were kind of hitting bottom. And there's the opportunity there for those to be counted as a single offense for the purpose of expungement. The last bit that we need to talk about is timing. If your conviction is for a misdemeanor, you are eligible to apply for an expungement 1 year after you complete your sentence. This is the part a lot of people kind of miss. If you're placed on probation for a year, it's not until the date that they actually let you off probation that the clock begins to run on your 1 year. This is for convictions, of course. Now, it's important to remember that there are a lot of fines and fees and costs associated with court. We get into arguments, you have to pay the fines and you have to pay restitution, but defense attorneys have been arguing, some successfully and some not so successfully, that court costs, which are civil in nature, don't count. So if you do need to pay fines, restitution, and court costs, pay your fines and restitution first, because the clock for expungement eligibility on your misdemeanor offense should start to run 1 year after you finish your sentence, even if there are some outstanding court costs. You may need a lawyer to argue that part to the judge, and you may or may not be successful, but most of us have had success saying that that's a civil fine, the court cost part, and it's not part of the criminal charge, it's not part of the criminal conviction, it's not part of the criminal punishment. It's just a fee associated with the expenses incurred by the system. If your offense was a felony, you have to wait 3 years. Again, that's from after you are finished with everything with the court. If you went to jail and you were released on post-release control, that clock doesn't start running until the date you are off post-release control. That's when your 3-year clock starts running. 3 years after that day, you get it. And the same thing applies for the expenses and court costs. If you have fines and restitution to pay those first, because we can make the argument that the court costs are not part of the criminal punishment and should not stop the clock from running for your expungement. But the other one, the fine and the restitution, that can be a problem. So there you have the 3 basic things. We have the exceptions, we have how you count the offenses, and we have the timing of doing the application. If you meet all the criteria, if your offense is not accepted, if you have only the 1 felony, or 1 felony and 1 misdemeanor, or 2 misdemeanors, including the special counting rules there for crimes committed at the same time, and 2 or 3 resulting from a spree within a 3-month period, and it's been 1 year since you were released from all your court-ordered stuff if it was a misdemeanor, or 3 years if it was a felony, then you are eligible to apply for an expungement. The application is made to the court that sentenced you. It has to be the court that sentenced you that you make this application to. If you were in a different state, you may be able to make the application to your local Court of Common Pleas, but how effective an Ohio expungement on another state's conviction will be is hard to tell. So if you meet those requirements, not accepted, got the right number, and the timing requirements, you can make the application. This doesn't unfortunately mean that your application will be granted. It's entirely within the court's discretion whether or not to grant the application. They can grant it, in which case your record will be sealed, and they can deny it. If they do deny it, you can always try again later. Like anything else involved in the criminal justice system, you would benefit from the help of an attorney making an application. The cost is not prohibitive for attorneys. Most of us will do it for somewhere in the neighborhood of $500 to $1,000, depending on the particulars of the case. And I strongly encourage you, if you are seeking an expungement, to contact an attorney and have them do the application and everything, assess your eligibility to be sure that everything is done properly. Because many applications are denied because something wasn't done properly, and every day that goes by that you still have a record that you don't need to have hurts you in finding a job. I hope you found this presentation helpful, and I'll probably be making some more concerning the others that are, what happens with the records that are dismissed and no bill and acquittals, and what are my options if I can't get an expungement, and hopefully I'll put those videos up later. Thank you for listening.